Yes.
Here now. Okay. Good evening, ladies and gentlemen. My name is Joseph Malcarney, and I am the chairman of the Zoning Board of Appeals. And we will start by asking my colleagues to introduce themselves, starting at my left.
Russ Tompkins.
Charlie Cannon.
John Calogero.
Frank McMahon.
Ron Mostello.
On the agenda for this evening, we're going to start with the Morse area variance and then the interpretation administration appeal. Have all adjoining property owners been notified and all fees paid?
Except for the publication, please.
Okay. The meeting is being recorded and live stream. So with that, we'll start with the area variance. Rich, you're here, you're ready. If you want to start by kind of explaining to us why you're here and what we can do for you.
Yeah. Just
Yeah, you
take
can
the
even take it
microphone
out.
Or put it, lower it.
You think you
take
can just
the-
pull it
the
straight
whole
out?
thing, yes.
Yeah. There we go.
Maybe turn it on.
Hello? You working? I want to put a garage where I park the cars right now. And I'm going to push it as far back as I can, but it will only be, the front of it will be 51 feet from the center of the road instead of 100. It'll be further back than the house. The house is a 1790s house, and in the old days, they built them right next to the road. There's a pretty severe drop-off on the south side of the driveway, so I can only go so far. And that's the long and the short of it.
Okay, thank you. Russ, you have,
When do we open up public?
no, we haven't opened the public hearing, so just if you want to review the planning board.
Well, I went over and met with the applicant, basically agreed with everything he said. He has an area now where he's parking, which is just gravel, and if you go just behind it, it does drop off, so it would be significant filling, and it'd be difficult to place it in any other suitable spot. I mean, you want a garage close to your house, and this is the most likely spot for it. The planning board has met on this, and in a letter dated August 21st, they approved the motion that they need a variance, Richard and Joyce Morse, to build a new garage at their residence, 610 Hollow Road. As he mentioned, be 51 feet from the center of the road instead of 100. They do not feel it would produce an undesirable change or character in the neighborhood to be further from the road than the house, which Mr. Morris has already said. Cars are already parked there. They added it might be more attractive to have the cars in a building instead of parked outside. The benefit cannot be achieved by some other means. The land available drops off sharply. Variance is substantial. Proposed variance would not have an adverse effect on the environmental conditions. The difficulty is self-created, and therefore is resolved, the planning board respectfully makes a positive recommendation to the zoning board of appeals for a variance. Well, they put 49 feet, but I guess it's 51 feet for the setback requirement for a garage, and it was passed 5-0.
Any further discussion from the board? Any comments? It is pretty straightforward.
Yeah, I was gonna say, this is an easy one for me, because this is exactly the reason I needed a variance for a garage. 20 years ago, my property dropped like a rock, and the only place to put it was near a side yard setback at that point, so I'm sympathetic to the need here.
Thank you. Russ, any other comments?
Just a motion.
Okay, I'd like to make a motion to open the public hearing.
Second?
All in favor?
Aye.
So moved. At this time, any comments from the public? All right, I'd like to make a motion to close the public hearing.
Second.
All in favor?
Aye.
So moved. Any further discussion from the board? Okay. Russ, your motion.
I hereby motion the Town of Clinton Zoning Board of Appeals grant an area variance requested by Richard and Joyce Morse, 610 Hollow Road, tax grid number 6366-4429-7, to section 250, attachment 2, reducing the required setback from the center line of the road from 100 to 51 feet. Whereas the applicant is requesting to construct a 30 by 40-foot garage near his residence on his 13.45 acre parcel. The proposed garage would be 51 feet from the center line of Hollow Road, when the minimum specified by the zoning law is 100. The proposed site is the most suitable due to the topography of the land near the residence where a garage would be located. The proposed garage would not produce an undesirable change in the neighborhood or be detrimental to nearby properties. The request is substantial but does not preclude the granting of the request. The variance being, well, I've repeated myself here. The variance is substantial, being approximately 50% reduction in the setback. However, this type of variance is common. The proposed variance will not have an adverse effect or physical effect, adverse environmental or physical effect. An area variance is type 2 action under SEQR and requires no further action. The planning board made a positive recommendation for approval of this variance at their August 20th meeting. Conditions: all fees are paid and any exterior lighting will be downward facing.
Second for discussion.
Second?
Any further discussion?
A comment or a question, I guess, really. Since there's a discrepancy between what the planning board reviewed and approved and what we're proposing, I think the planning board was 49 feet, you said, Russ?
Yeah, I was surprised when I just read that.
Yeah, no, it'll be 51.
Well-
Hopefully it'll be like 53, but it'll definitely be 50.
I was wondering if we wanted to change or edit to say not less than 49 feet or not less than 51 feet, because 51 feet is dead on the mark. Do we want to say,
Rich?
Not less than 50 feet is fine with me.
Okay, so every place there's 51 in that, I will,
Leave it 51, but you've got it in there. Doesn't make any difference, 'cause it's
Well,
going to be at least 51.
If they said it was a 49 variance, they're right.
Okay.
If that's 51 feet, then it's 49 feet left. Right?
the law is looking for 100. Right, yeah.
Right.
The setback requirement is 100,
Right, but if it's 51 feet back, it's 49 is what's missing.
the
I
balance.
think,
So you're
they
not
got
right.
the 49.
That's what's
because
left
it's going
over.
The other way around.
Yes.
but it's gonna be
It's the balance of the 51, yeah.
Right, yeah.
But if you, my point was more, if you wind up putting it 51 feet 6 inches, technically you're not compliant, because it's saying you
No, no,
will be.
52
No.
and 6 is fine. It's if it's less than
If it's
51
less
feet.
than 51, I'll be in trouble.
Right.
It'll be 51 or more.
That's why I was suggesting the no less than, but we have room for error is what you're
Oh,
saying,
no,
Joseph.
it's gonna be at least
Yeah.
51
Yeah.
feet back.
Okay.
Right, right. So if 51 plus is fine, it's just if it's 51 or less than 51, then it becomes a problem. And if Rich is saying it's gonna be at least 51, that's not a
Okay.
problem, then I think we'll just go with Rich's recommendation. But that's a good point. I often make the point, because if they're like, well, I have it right at 51 feet, then let's give him a variance at like 49.
Right.
But if he's saying 53 and 51 is good, then I think that's
Okay.
fine. Okay, any other comments from the board? Okay, Ron, your vote?
Aye.
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 Aye. Your variance has been granted. Rich?
Thank you.
Yes, thank you. Okay, next on the agenda, we have the John, is it Kasia? Kasia? How am I pronouncing? Okay, Kasia, yeah. Interpretation, so.
Good evening, everyone. My name is John Lyons. I'm with the firm of Grant and Lyons, and we're representing the appellate, John Kasia. I don't have a lot to add for you this evening. The only thing I'll mention is on Monday of this week, I sent you a memo. I've asked that the recording of the July 16th Planning Board meeting be entered into the ZBA's record on this matter. And the two primary reasons I wanted the recording as part of the record, and also I was hoping that maybe some of the board members had a chance to look at that recording, is because Mr. Schilling did appear at the planning board meeting that night and did talk a little bit more about the work that was done on the site, and so I just wanted that information to be in as part of the record. And the second reason was because the planning board meeting raised some concerns for me about the manner in which the planning board was thinking about whether a wetlands permit was required here. And my hope is that if the board agrees that a wetlands permit is required, my hope is that the board can offer some direction to the planning board about the requirements of the law that you're interpreting as part of this process, and pass those along to the planning board to assist them in implementing the next step of the process.
Great. Thank you.
Other than that, if you have questions, but I don't have anything else to add.
Thanks.
Thank you.
Okay.
Did we reopen the public hearing?
So the public hearing's still open,
Still
so yeah,
open.
we can
So,
certainly take
Are there any
comments.
other, Ms. Brown, would you like to speak? Why don't you, can you come up?
Yeah, I will.
And if
Just
you
go in
can,
a microphone.
you can take it out if you want to sit down, which is fine. That way anyone watching will be able to hear. So I'll just kind of.
Just pull it up.
Without the microphones, the recording isn't all that useful.
So, we couldn't be here for the last, when you guys met last, and I gave you a letter that I just want to know if you all had a chance to read it. Did everybody read it? And I'm just wondering if you guys, has everybody here looked at the project on our property? You all know what it looks like as of fairly recent?
Today?
Oh, good, okay. All right. So, I mean, you know, I guess we feel like, after reading the most recent, not the memo that John Lyons is talking about now, but the memo, I guess that was around the time of the last ZBA meeting. When I read that, it sounded like the main concern is that we have done something to affect the way that the water is flowing to the wetlands, and that would affect the wetlands, that they would be drying out, and that would be affecting John Casia's property. And so that's definitely not what's going on there. And I'm not sure, I guess I kind of want to know, what questions do you guys have about what's happening at this point? Because there are these two triangles that come of wetland that come into that part of our property. Those have not been, we haven't done anything to those, that we have not created a pond, that area always had water in it. All of the water, it's like a basin. It comes in from all angles. We're at the foot of the hill, and then it continues to run the way that it always has. There's nothing that's changed. There's nothing that's been obstructed. I did speak to Winnicke, because I have a friend there, and she put me in touch with one of their scientists, and I was explaining what was going on, and she said, if it's not a DEC property, then if it's not a DEC wetland, then the 100-foot buffer doesn't apply. I don't know.
That's not correct. Town law has buffers that cover town-regulated wetlands. And those buffers are either 100 or 50 feet, depending on the size of the wetland.
Okay, so she was surprised by that. But, so, yeah, so what do you guys want to know at this point?
Can I just say that, strictly speaking, what we're here to do is to actually review the determination by the MCEI, not the details of the work that's happened over the last year in that wetland. It's, the planning board under town law has the authority to implement the town wetland law, which I'll spend a little bit of time talking about after the public hearing's closed. But the zoning board, we don't review the planning board. We're not given that, and frankly, I don't want that authority in case anyone's thinking of giving us that authority. They work hard, they have the access to the engineers and the expertise, but we are charged with reviewing determinations made by the MCEI, by Jeff Newman, and in this case, that's technically what was appealed to us, was that was asking us to interpret the determination by the MCEI, by Jeff, that the planning board should waive the requirements of the wetland law and immediately issue a wetlands permit. And so that's actually what, strictly speaking, that's what we're supposed to be doing. Now, we can say what we think about the wetland law and encourage the planning board about how we think about it, but fundamentally, the planning board is charged with implementing the town wetland law. So the details are relevant, but they're only relevant insofar as they influenced what Mr. Newman decided in his recommendation. At least that's the narrow issue that we have to deal with. All the rest of this is part of that, but that's really the issue we have to deal with. Is anybody, okay.
I just, like, when I'm reading some of the things that are being said, like even from the beginning, that the lawyer is writing about what's going on, like, so much of it is not true. Some of it is like, just like including information that's no longer valid from when the CAC came and did the visit, which was really when we were applying to put in a tool shed. But that information is all still being referred to as though that's still So some of these things, I just don't know what to do in terms of, like, is it up to me to give you to go through a long list of, like, disputing all the things that the lawyer is saying, or does it really not, does it not
Well,
matter?
that's, the point of an open public hearing is to allow anyone to speak, and then it's our job to sift through all that. So we sit here quietly and listen to everything that's said. And I can tell you from the Sixth Senses case, we sat here for hours and listened quietly without judgment to everybody's point of view. And then we have to sift through it and figure out what that's been said is relevant to the specific thing we have to do. So we're open to hear anything anybody wants to say, and that's the point of a public hearing.
Okay, well, the first thing is just that back in February, Attorney Lyons was, I did a FOIL request, so I read a lot of the emails going back and forth, and he was emailing Barbara Mansell at the CAC and giving her misinformation about what we were doing. So telling her we were putting in a parking lot, which we certainly have never applied for, we are not doing, but that the project had been started, I forget what year, but years ago, that we had started this project, which is like 100% not true. And, you know, other things, but when I saw that, I sort of questioned, like, how that would be okay, that, like, he would be giving her information before she had even been, like, we didn't even know who she was. We didn't even know that the CAC would be involved in any of this, and he was attempting to certainly give her his side, which was not accurate information, where we didn't even, you know, we didn't have that opportunity, and, you know, so that seemed very questionable. And, yeah, and then, you know, just in turn, I mean, you know, I'm tempted to, like, go through this whole letter that I sent to you, but you know, the idea that, I mean, it sounded like there was a question about, I mean, this all started with a different project, which we dropped because it became so onerous and fraught that we just said, forget it. And what we have done in that area has not had any negative impact to the wetlands. We haven't, you know, we've brought in native plants. We met with the DEC. We met with Dutchess Soil and Water. We met with, after seeing you guys originally, you suggested that we hire the town engineer and have him come and weigh in. We met with him. We did what he asked, which was really just to reinforce some of the areas around the wetland that could be, you know, where there could be erosion, and to put in more continue to put in plants. And, you know, we removed poison ivy. I know that there's, like, been a lot said by John Lyons about poison ivy not being an invasive species, which, of course, like, that is true. It's not an endangered, I mean, it's not an invasive species, but it is a dangerous species, and it was actually completely taking over that entire area and was really bad for the diversity in the area, and it was just strangling some of the trees. There was tons of dead trees amidst people just dumping stuff in there. So the idea that, like, I don't know, it's just been just so much over, you know, I don't really see any evidence that there is anything that we've done wrong or that there's a problem, but, you know. And I guess additionally, I would just say that, you know, John Casey, our neighbor, I mean, there's a wetland that we, you know, share. That wetland is actually, like, there's a spring on that wetland that continues to feed that area. It's not going to dry up, as he's saying. And all of the water continues to come in from, like, 3 different angles because it's a basin there. And John Casey's pond on his property is, you know, that's a man-made pond. Like, that pond was created back, you know, I don't know, like in the 1950s or something. And they rerouted the stream that divides our properties to, like, feed into that. And, you know, there are many, like Elliot Werner, as I said in this letter, recently rerouted the water on his property that goes into his wetland. He rerouted it and created a pond in the front of his house and then planted 2 willow trees. And I'm not sure, you know, like, there's so many things going on. John Casey planted, I mean, there's a stream that runs, like, it's almost like a, you know, a boundary between our properties, and at the left corner of it, he put in, as a screen, he put in, like, a whole bunch of river birch and evergreens that are within 10 feet of feet from the stream at most. There's another neighbor who, you know, has a stone wall, that's like completely on an easement, you know, who's just like, it's like 3 feet from the road, so it's clearly like in the easement. I mean, I don't really care about any of this stuff. I want to get along with my neighbors. I've actually sent John Casia numerous emails saying, can we talk about what's going on? I see you have a lot of, because he has had a lot of construction going on at his property. Could we talk about it? It'd be a good idea to just exchange phone numbers if there's ever a problem. And no response, ever, to any of it. So I think that's too bad. I think that, you know, if like the solution to things is just like getting a lawyer and just paying them endlessly to drag something on and on and on. I mean, the idea that, like, you know, by letting us do what we're doing with our property, that's setting some type of terrible, as he said in his letter to the town, that's setting some terrible precedents that then will affect all of the decisions going forward for the wetland laws. I mean, I don't know. I mean, that's just completely insane. But in addition, it's like, to me, like, having this go on like it is setting a precedence of just, like, wasting so much of everybody's time. And, like, you guys, you know, and the planning board, and Jeff, and Arlene. It's like, if somebody can hire a lawyer and just, like, complicate things endlessly just because they have the money to do it, like, that's a bad precedence, in my opinion. And, yeah, and, I don't know. I don't know what else I have to say. I mean, I guess that's, you know, that's pretty much it. Thank you.
Thank you.
Further comments?
Any further comments?
I just have one comment. I wasn't aware of the letter that was submitted by Ms. Brown. I'd like to request a copy of that letter and an opportunity for a little bit of time to respond to that, if any response is necessary.
You can have my copy. Arlene will send you one electronic.
Thank you very much. Otherwise, the only other thing I want to say is that I disagree with
It was 2
Ms.
pages,
Brown
wasn't there?
in terms of the allegations that I've provided inaccurate information. All the information that we provided to bodies of the town of Clinton have been accurate to the best of our knowledge. Thank you.
Thank you. Any other comments? Catherine? I'd like to make a motion to close the public hearing.
Second.
All in favor?
Aye.
Aye.
So moved.
So, folks, we have 62 days to do this. What I was hoping tonight was just to say a few comments about how I see this, and then get some get a sense of how everybody else is thinking, because I presumably have to draft an interpretation, and it'd be nice to know what your thoughts are. So I'll distribute that by email, and everybody can chime in. But let me just say a couple things about the wetland law. I'm actually quite proud of the town's wetland law. It's a very strict law, I believe. I think it lays out very noble purposes to protect wetlands. I think, the history in this country of wetlands is that tens of millions of acres of wetlands were lost, particularly in the early days of the country. Farmers drained them, and they were often the richest soils, particularly here in Dutchess County in colonial times. If you wanted a farm field, you found a wetland and you drained it, because that's where there was decent soil. Actually, an old beaver pond was everybody's favorite wheat field 200 years ago. But across the country, until modern wetland laws were passed at the federal level in the 70s, and then at the town level, this one, I don't know actually the original date, wetlands were being lost, at a pretty alarming rate. And wetlands serve, all sorts of important functions, both for biodiversity and for, stormwater runoff and drainage. New York City is looking at restoring its wetlands to prevent storm surge and hurricanes. So I think I actually think our wetland law is quite well-intentioned and well written, but it's the planning board that implements it, not the zoning board. And it seems pretty clear to me that, so for instance, we're here to grant variances when people have a compelling reason, but we have to grant that variance based on a set of factors that we have to show the application meets. If you look at the wetland law, the list of factors is even longer. So my take on this law is that there has to be a good reason for somebody to want to do something in the wetland. And we'll get to exactly the language of the MCEI determination in a minute. But, to me, we have both a very well-written law that puts pretty strict standards on, you have to have a really compelling argument if you want to do something in a wetland. And that's what the law is designed to do. And I agree with that. I think that's great. And I trust the planning board has the same feeling about this. And yet it is within the planning board's purview to look at a project and say, yeah, there's a compelling reason for doing this, and it meets all the factors in the law, and we will grant a wetlands permit. So the point here is that anything done, and really anything done in a wetland or the buffer, needs a permit. And I think the planning board is pretty expeditious in dealing with this. We have a process. We rarely have to deal with wetland permit issues because we count on the planning board. If it's in the wetland or the buffer, we ask, has a permit been issued? If not, then it rarely comes to us, right? So that's my take on the law itself. With respect to the MCI determination, that's where I respectfully disagree. As I read the key statements, the word any is emphatic. It means you basically cannot put anything into or take anything out of a regulated wetland or the buffer without a permit. It's that simple. The fact that it's that broad, to me, reflects the goal of the language. It's, in other words, don't mess with a wetland unless you go get a permit. And if you're going to get a permit, you're going to have to convince the planning board that you have a good reason and that you meet all the factors. And so to me, that's this notion that any is vague is where I disagree. To me, it's about as emphatic a word. You cannot deposit materials or remove materials, any materials, from a wetland. That includes plants, that includes dirt, both of which were done in this particular case without a permit, clearly. That's not debated. That's actually in the determination. So, I watched the video, and a lot of their discussion was, is this de minimis? Is this just so minor that there is a provision in 250-78 where the planning board can waive all the information requirements and just say, yeah, this is really minor. We've had cases where somebody was, putting a deck into the buffer and they needed to sink a post. And yeah, do they need engineering studies to know that that's not a problem in the wetland? It's in the buffer, not in the wetland. No, I trust the planning board to do that. That question of whether it's de minimis is actually the planning board's decision. I happen to think that what was done here has no bearing, no relevance, to be honest. I don't think it was de minimis. I think you should have gotten a permit and had a compelling argument for why. I drove by there, and what was done was basically change a wetland into an upland garden. A big part of the area is no longer a wetland, likely because of the fill that was brought in, and there were lots of ornamental shrubs planted in. So, to me, that's, that clearly required a permit. It's just not debatable, and I don't think Jeff debates that it required a permit. The point is, You know, in the determination letter, it was really this notion that somehow any was vague enough that someone should be allowed to, you know, there's nothing in the wetland law that says that you can beautify a wetland, and that exempts you from a permit. Wetlands are not necessarily all that attractive. They're often pretty messy. You know, trees die in wetlands all the time. A beaver comes in, raises the water level, and for the next 50 years, you've got a bunch of dead trees around. You know, on Schoolhouse Road, there's a massive one, you know, and actually the herons like it for nesting in for the next 20, 30 years. But, you know, they're not always attractive, and I sympathize. I am dangerously allergic to, or sensitive to poison ivy. But I'm careful. It's not a health risk. You just learn to be careful. It's not attractive. Poison ivy is doing quite well. There's actually recent research that a rise in CO2 actually makes poison ivy grow faster. So particularly in the South, poison ivy is actually growing faster than it used to. Go figure. But, you know, the notion, so ultimately, I don't want to try to tell the planning board what they should decide about the facts of this case. But the notion that any was vague, the word any was vague and meant that this was almost by definition de minimis because it was just, quote, improving the wetland, to me, is not in the law. That's, you know, the notion that, you know, we all have an urge to beautify our yards and our properties, but wetlands have a special level of protection under this law. So I'll stop there. That's sort of where I am on this at this point. And I'm hoping to hear from the rest of you, so I know if I'm way off base.
Sure, if I can just clarify one thing. Charlie, I just want to clarify one thing that you had said earlier, was that, that the appeal is against, or from my determination that the planning board waive all requirements and issue a wetlands permit. That was not my determination. My determination was, my recommendation, right, was that they waive any future requirements under the exemption clause in the law, and follow that exemption clause, which would allow them to issue the wetlands permit. But it wasn't a determination that they should issue, because again, that's the planning board's purview, not mine.
Right,
So
okay,
I just want to be
yeah.
clear that I wasn't determining that the
Right.
wetlands permit could be issued.
Thank you.
Yeah.
So what do you,
disagree with that, just for the record. Okay? I think it is a determination, and the planning board treated it that way following it, but I just want to.
I think the letter says determination, that's why. I think you put that word determination from the bottom, that's why it got confused.
so what do you all think?
Well, everything that Charles said, I agree with wholeheartedly. I think any is a specific term that says anything. It doesn't mean, I don't think it's vague at all. I think it's very concise, that use of the word any. I mean, obviously, work was started here. There was a stop work order issued. There was a reason for them to apply for a wetland permit. It's been changed because now they've said, okay, they no longer want to put a building there. That still doesn't affect the fact that work was done there. It was started. There was things done. There was soil moved around, soil added, paths changed. There was a ditch that apparently was dug with a backhoe or something. So there's no doubt that there was disturbance in it that affected the different sections of 250-78. And if the planning board wants to come out and say that they don't think it's significant because of a small area or something, that's their purview. But I disagree with Jeff's feeling that it was vague. He is recommending to them that they issue a permit. He doesn't have the authority to tell them to issue it. But I disagree with his interpretation of it. Basically what Charles said.
I'd like to just go back to de minimis for a minute. As I remember, the town's wetland law was at least partially in response to the DEC kind of announcing that they were going to put more of their resources into larger wetland areas, and that the burden for evaluation of smaller areas was going to be put upon the town. I don't want to argue the politics of that, whether that was a good move or a bad move. It does put a burden on the town. The word, I happened to take Latin in high school, so I was kind of taken up with de minimis, and I looked up and found a couple of interesting examples. One legal application of the term says that if you have $1 million deal and there's a $10 discrepancy, that's de minimis. Since the town is burdened with having to deal with smaller wetlands, they might want to consider what size and up do we consider, or what size and down do we consider. At this point in my mind, you can't dismiss any size and say that's not relevant. We know what the purpose of wetlands is to our drinking water supply, to our general health, to the ability of a town to have an aquifer that's wholesome. I'm a property rights guy, and I've been through the ringer with the DEC myself on getting a permit when it was a DEC permit, not a town permit. So I'm really troubled by the way that term was used and the way it was kind of, I don't want to say ignored, but looked upon as a reason for coming to a decision by the planning board. And that being said, I think that what was done, the items that were discussed at the prior meeting by the property owner, it kind of falls right in our regulations as the things that can't be done. Draining, dredging, removal of material, filling, depositing. And I got to tell you, with the wetlands on my own property, it's not a pretty thing. It renders parts of the property totally unusable. But the facts are that those are the plants that do the job that the wetlands is supposed to do for us. So I'm troubled by it.
I really nothing more to add, except to, I agree with the points that most of you have made. And when the law says any, that's really it, and it takes a lot to overturn that. And that's really not. I said, I agree with everything that's been said here. And when the law says any, it's gonna take quite a bit to overturn that. And that's just my feelings.
I guess I'll say that, and Charles, I think your overview or your summary is, as usual, spot on. And I took some notes for myself for some key points that Russ had already touched on, so I don't want to, go back and rehash that. I guess I'll say it's difficult to separate what we know has transpired or occurred there at this property from our reason for sitting here tonight, which is simply the determination. So I guess where it falls for me and what helped me to get to the point that I'm at tonight is having a chance to look at those maps that we were able to view last month, specific to this property. And it's pretty clear based on those maps that this should not have occurred without a permit. Whether or not a permit is issued remains to be seen, but those maps for me are the deciding factor in how I think we need to proceed tonight or in 62 days.
Let me just add one more thing. Seeing exactly where the wetlands is and the buffer is, I was in a position of granting a permit or not, which I'm not, that would be de minimis, at the very least. I would need to see those things.
I'm not quite sure I follow. Can you clarify that?
Yep, I can. There's, to date, I don't think there has been a very specific, basic delineation of where on the property exactly things currently are. And the board should have that at their disposal, the planning board. Okay, as the DEC backs down, they're gonna have to make many more of these determinations, particularly on smaller parcels.
These weren't there when I first looked at the property.
You know, this is something that the CAC has been talking a lot about. You know, Paul Thomas and I have met, Catherine's been there, and, you know, this is going to be a real challenge for small towns. You know, we discovered that the town of Woodstock has a wetlands biologist on their town staff. Boy, be nice. Does anybody want to have your taxes go up to hire a full-time wetlands biologist? No. So there are a number of proposals for ways to try to make it clearer for a landowner so that you could just go on parcel access and say, well, gee, if I'm gonna put a driveway here, it's gonna be in a buffer, I better go get a wetlands permit. We need to make this efficient and clear without a huge cost burden to landowners and a time burden to the planning board. And so there's some various proposals that are out there that, you know, because DEC is backing off even more, they're gonna put more stringent regulations on, but not provide maps, so that you're gonna have to, you know, you're gonna run a big risk. If it's turns out to be a wetland the DEC cares about, and you stumble into it without getting a permit, the penalties are gonna be quite substantial. So, you know, I'm hoping that there's something that the town board can do that makes it clearer for people. But, you know, again, I still come back to, so Jeff had 7 determinations and 1 recommendation. And, you know, some of those determinations I think are spot on. You know, there doesn't seem any question that the work was within the boundary of a wetland as regulated by town law. It's also not a DEC regulated wetland according to the current maps. And, you know, it was this notion of the vagueness of any, and then the one other thing in there that was this notion that this was improving the site. And yes, you know, it's human nature. We all like to clean up our yards. I've actually written essays about why cleaning up after nature is a bad idea. Ecologically, neatness is not a virtue was the title of that essay. But it's human nature. And yet there's nothing in the law as I read it that says that, you know, quote, improving. There's a whole field of restoration ecology, a whole discipline. Largest subdiscipline is wetland restoration. It's really hard work and rarely works, to be honest. There's a large literature. I advised a graduate student years ago, Arlington High School. Under federal law, you can, if you have a really compelling need, you can destroy a wetland as long, you then have to create comparable wetlands somewhere else. And so Arlington High School was expanding, I think, their ball fields or something, and they had to go out and try to create wetlands because there were Blanding's turtles. And so Tanessa's master's thesis was to try to see whether this created wetland functioned as well as natural ones. It's very rare that they do. It's really hard work. So, quote, improving a wetland is a real challenge, and aesthetics are just not anywhere in there, right? So I'm sorry, they're not always pretty, but they serve really critical functions. And so I disagreed with that part, that it was okay, the proposed project achieves the stated objective to minimize negative impacts because it is specifically designed to improve the area. To me, that, I guess the message I would like to convey with the greatest respect is that, you know, that I would like to see the MCEI take a very, and I don't know, strict is maybe not, but you know, adhere to the letter of this law first, and then let the planning board decide, right? Let them get all the information together and say, well, yeah, you know, this is this is de minimis, this is sufficient under 25078H, I think it is, that we can waive most requirements and just immediately issue. Or we need study, and we need data, and then go through the process. And then it's the planning board's determination whether what was proposed meets the law. And I don't want to be involved in that part of it. Yeah, you know, that's the planning board. I have great respect for the work they do, and I don't, you know, we don't, there's nothing in the law that gives us the authority to review planning board determinations that I can see. So,
Can I just say, like, the part of, I mean, we're not just beautifying the area. People were dumping in that area since I bought the property 18 years ago. People were dumping waste, construction waste, tires, glass, you know.
I know this seems like,
Well, I just
no, it seems onerous, but strictly you should have, yes, you should have asked for a permit to remove the waste. And I think that, you know, it would have taken you a month to go through the process of getting on the planning board agenda and telling them what you wanted to do, show them some pictures. And that's what we're saying here, is that the law,
I agree with you. I totally agree with you. I totally understand everything that you're
Yeah,
saying.
right.
And I have so much respect for what you're saying. But I just want to make the point that we were not just like, you know, suburban, like homeowners trying to beautify every inch of.
well, it looks very attractive now, but it's not a wetland. And so,
Well, the wetland, though, still certainly is still there. The
the-
buffer, yes, the buffer of the wetland has been changed.
Yeah.
But the wetland itself has not changed.
I'm going to leave that up to the planning board. From my driving by it over the months, it did appear to me that what had been wetland before had been filled in and had ornamental shrubs planted in various places. But that's, again, that's not, I'm going to let the planning board deal with that. I don't want to dispute, because we, you know, sitting here, we don't have the data.
Any further discussion or comments that may be helpful for Charlie as he prepares his motion? Or any questions that you would specifically?
No,
We don't do
do we need to, presumably we run this by Shane, and so I'll send a draft out the next couple, well, I'm going to Maine, go hiking for a week, so when we get home, I'll send a draft out of something. To me, it's very straightforward. It's really those 2 points, that any means any, and improving is not specifically in the law, and would need to be presented to the planning board to decide whether it's consistent with the law. Those are really the only 2 issues that I had with the 7 determinations.
And just as the reminder, really what we're looking at, again, is that letter from Jeff to go through it all and rewrite anything that we feel may be inaccurate. So really it's just the letter, not about what's happening on the property or any of the other.
You know, this is pretty much the way, Jeff works with us on variances. He doesn't tell somebody, oh, zoning board's gonna give you the variance, so you don't need to go to him, right? So he's gonna deny a building permit because it's within the setback and let us make the determination. The same thing with wetland permits. He's making just a recommendation at this point to them, but it was, I was a little worried that the language you were using would sort of open us up to the sense within the town that, ignore that law. It's really,
De minimis.
it's de minimis.
I'll say that this type of discussion is really important, right? It's not dissimilar from discussions that have been had among the planning board about steep slopes. It's similar, and the question is any disturbance within the 10,000 square foot area, right? And I think that this is a very valuable conversation, because there is a lot of seemingly innocuous and innocent projects that can happen, not in the wetland, but 99 feet from a wetland.
Yeah.
Somebody planting a garden, right, does that fall under any and require a permit? And that's why these discussions are important.
And, you know, my take would be, unfortunately, yes, it does require a permit, and hopefully it'll be a painless and quick determination when it's so obviously de minimis.
Yeah, and again, to reiterate, it doesn't mean that such a thing cannot happen.
Right.
It simply means that such a thing would require a permit in order to.
And that, I think that's all I really want to see happen here, and that I think we, as the zoning board, that's, to me, the extent of our role here. I know that, you know, the attorney suggested that we should try to educate the planning board, and I'm loath to do that. I have a great respect for the work they do. It's a hard job, and I am always thankful that we don't have those 3-hour meetings that they have. So that's where I am.
Thank you. Any further discussion on this? Okay. All right, well, we look forward to getting your email when you're ready, and
Good.
Don't fall off a cliff in Maine.
Yeah, or get caught by that 15-foot tide.
Yeah.
So when are we reconvene?
the
Next
next,
meeting?
the next.
Yeah, I would, I don't see it, there's no reason to put this off, so we, what is it, whatever the fourth Thursday is. The 26th?
No. September, only for Thursday, yes,
Yeah, so on,
I'm coming back at 25th.
there's plenty of time. For people? Oh, so you want me to wait another month?
Or can we do on a week, probably? What's the week? Is that, let me see the calendar. 6. Yeah, I guess the first week in October. Is that right? I'll be
You
away.
turn off the mic if you want.
It's- I wondered what it was
I'll be
too.
away. I gotta go.
Yourself.
I gotta go.
Okay.
I have a Europe. I have to go to London.
Okay, so whenever we meet again,
Yes.
whenever we meet again, hopefully by then we will have a
Yeah.
draft that everyone can discuss and vote on. At this point, you know, legally, we now have 62 days. We have 62 days to make a determination in response to the appeal from the applicant. So we will be sure to do it within 62 days. That's, at this point, I guess all I can promise you, because it's not entirely clear when our September meeting is. Yeah, let me just, Jeff, that's a good point. My understanding is that you should be doing nothing in that area. There was a stop work order issued, a lot of work continued. I'm certain I'm correct about that. I don't believe it should have, but at this point, nothing should happen in that area until a wetlands permit has been issued. Is that correct, Jeff?
Well, just so you know, it wasn't like we were just like, oh, who cares what they think? Like, we got the stop work order, and then we discussed with Jeff what we put into the two, and that's all that we've done.
Okay, yeah, but at this point, please, at least my understanding of the law is that you would be in violation of the law if you continue to do any activity in that area. Anything. Anything you put in or take out is a violation of our law without a permit. Anything.
I mean, if you look, when this first started, when you were applying for the variance to build the shed there, and I was there, and since then you submitted pictures, and the pictures have numerous plants and vegetation that's been planted, which seems to be in violation of the stop work order. You know, all work should have been.
Just so you understand, if that's the case, that's just not what we were told. We really were like hyper vigilant, like asking, what can and can't we do? And the town engineer came and, you know, you guys told us, meet with the town engineer and then follow what he recommends and then talk to us once you've done that. And he recommended planting things, like that's in the report that he gave, we paid $500 for him to come and
Did
he
we?
gave us the report. He gave you guys a report that showed what he was telling us to do, which was planting things.
But that was the planning board, I believe, not the zoning board.
No,
variance.
You need to get
A
a
shed.
Oh, this was,
engineer.
okay. When you applied for that variance, weren't you at that point under a stop work order?
Yeah, when we
Yeah.
applied for the variance to get the shed, put in a shed, we had a stop work order.
Yeah.
And the, the recommendation was for the town engineer to come and tell us what to do overall in that area. And that was part of what he recommended, and you guys got that letter. I'm just letting you know.
Yeah, I'm just saying that for the purposes of going forward,
That's fine.
yeah, nothing should happen.
Okay, I hear you. I just don't want it, because Russ was just indicating, the way that he was saying it, it sounded like he was saying that we are just like recklessly doing whatever we want in there, it's just not.
And again, that, that's really the planning board's issue. But at this point, while we are considering this, the planning board motion held in abeyance their issuance of a permit until they've gotten until they see. Now, there's nothing to say that they couldn't look at us and still follow Jeff's recommendation, right? I hope that's not the case, because I don't think this is de minimis personally, but that's up to them. And, but until we give the planning board until we adopt a determination, and they can look at it and decide what to do next. But until then, my reading of the law is that anything put in or taken out of that parcel, of that part of your property, would be in violation of the law.
The whole area? The whole area?
Yeah, the whole area. Yeah.
Even if it's beyond 100 feet?
No, the area that's within a wetland or the buffer is covered by the town law, right?
Beyond that?
Beyond that, no, the rest of your property that's outside the buffer is not covered by the wetland law.
So it's a 50-foot buffer?
I believe it's 50 on their property.
On your
It's
property,
below.
I don't know, again, this is the planning board, that's a determination from the planning board. We don't have them,
Location of the wetlands never been determined.
and that's a problem.
50-foot buffers don't mean anything right now.
Absolutely.
Until there's a back wetland bound.
It could be 100. If you want to ensure that you are not in violation of the law and subject to a penalty, you might want to stay away from, assume a 100-foot buffer, but that's your decision. It's just, right now, we have 62 days to come up with a decision, and I don't know exactly what it'll say. It'll, we'll have a draft, we'll probably amend it, and then vote on it, and then the planning board gets to go from there. Isn't that? Yeah.
Okay, all right. So at this point, we will wait to hear from Charlie, and we're moving on to review of the minutes.
So thank you all.
Thank you. Okay, so we have the July 25th, 2024 minutes. Should be in your packet,
Yes, it's with,
and you have the updates here.
yeah, that's okay. All the red.
Okay, all right, good. All right, so starting with page 1. Yeah, this is the one that has your marking in red. Okay, sure.
There's one behind it.
Okay, page 2,
This was very clean, I didn't find anything.
page 3. Yeah,
No.
this is just if we have any, because it looks like we have the notes that are highlighted, correction to the,
Yeah.
no, you have them right here, right?
Oh, yeah, that was me,
Yeah.
the red is Charlie.
Yep.
The blue is me.
Okay.
and
Page 4,
Ross.
page 5, page 6, page 7, page 8, page 9, then you have the notes from, these are Charlie, right? Yeah, some clarification that he has outlined in red. And the next page, page 11. Any comments or adjustments to any of the minutes from the edits that have been made already?
No, the edits caught, I think they were all caught.
Okay. I'd like to make a motion to accept the minutes as amended.
Second?
All in favor?
Aye.
So moved. Any further discussion from the board?
Should we come up with a date for?
Oh, yeah. Let's come up with a date for next month's meeting.
Talk about it. Okay. So we can't make it before, it gotta be after. First week of October, guys, or we just wanna do it on the October meeting, it's up to you.
So that would mean 2 meetings in October?
That's what I'm saying, or we could just combine, or you just,
Or
we
we
just
do
do the
like-
ruling
Or we
in
do like
October.
October 17th. Oh, I'm not gonna be here that week, actually.
Does anybody know Columbus Day weekend? What
Oh,
the date is of that?
12, 13, 14.
Okay.
Yep.
Charlie, we're checking dates.
What is it, Judge?
12, 13, 14.
October. Well, we're thinking about, Joseph was thinking about 7 days, you say 7?
No, I won't be here.
No. Well, why don't we just do October 24 and have no meeting in September?
You don't think they're gonna be variance requests?
Well, because I'm not gonna be around.
Without meeting, you do not meet.
I'm not gonna be around. The meeting is already next week, and I really don't have a variance, so if I don't get a variance for the
Right.
meeting till
Okay.
next
There's,
week,
then there's no second planning board meeting in
yeah,
September.
because I'm not
okay.
gonna be
Perfect.
around,
No,
so
that-
that's what I'm
Yeah,
saying, so we
I like-
really don't have
I
anything
like
for
that
September,
idea.
I like
you know
that
what I'm
idea,
saying?
I'm sorry, it
Sounds good.
slows things down, but that's,
Yeah,
we're still,
because
We're
the
still-
meeting
you're
is
still on the
next
clock.
week,
We're
and
still
there's no
compliant.
variance recommendation, I'll be gone
that's
from
only.
the,
That's the 24th.
from the 15th
So
to
we're good.
25th,
Yeah.
so.
Yeah,
Okay, so
okay.
this will not, we're just gonna skip the September and.
Uh,
24th.
Oh,
So it's
everybody-
October
Everybody's
24th.
gonna make it?
October 24th.
But then it
24?
would be 58 days, you said, Charlie?
Yeah,
56.
56, it's
56.
exactly
Yeah,
8 weeks.
it should be fine.
So that, so
We did two
Yeah.
months.
decision would very likely be that day then, unless you're gonna add a meeting within 5 days of that day.
Correct.
I think
It forces a vote on that date almost?
Yeah,
Yeah,
right, no, we have to
Yeah,
vote.
I think,
Yeah,
I
that'd
mean,
be fine.
I think it's pretty, I
Yeah.
think we're,
Yeah, no, it's a big deal.
yeah.
Yeah,
Okay.
no, that's
It's
fine.
just simple enough,
Okay, October 24th it is.
Everybody's gonna be here?
So far, barring, who knows what.
14 through 18, yeah.
Yeah, I have a
I come back
meeting
on
soon.
before that anyway, so.
All right, 7 o'clock, our meeting
Yep.
starts now at 7.
Yep.
Okay.
Bah humbug.
Okay, any other further items? I'd like to make a motion to adjourn this meeting. All in favor?
Aye.
All right.
So moved. All right, thank you, gentlemen.
Lindsay, October 24, we're not gonna meet in September.
So, Charlie, thank you.
It's not necessarily a suggestion to the planning board, it's
We
our
had a
interpretation
building from
of
the
Jeff's
old shed.
letter. And they will look at it and then decide on the proceeding. But, you know, I think you have a sense that,
So that closed this, that closed the
that,
old permit from getting the CO.
so for instance, if we decide that,
So then the new permit.
you know, simply improve, well, doesn't really matter what we decide, it's still gonna be up to the planning board to decide whether what you have proposed, how they wanna deal with it in terms of whether or not to grant the permit. That's the next step, but they're saying they will wait, very graciously, to see what we think about the information they got from Jeff, on which they based their motion a couple weeks ago.
said what he thought, and then the lawyer contested that, and that's